the lawsuit for whatever reason, but became aware of it once a default was taken, contacted us, and we filed a motion for new trial and answer. And in this particular instance, the Craddock, three prongs of Craddock really don't apply, because plaintiff's counsel is in agreement to set aside the default and agree to a new trial. But why we're here and why we're having this issue is plaintiff's counsel is alleging attorney's fees and would only agree to a new trial if said attorney's fees were paid. And that's not a condition as required in the rules for setting aside a default and granting a new trial, which I think, even by their own admission, we've shown ourselves eligible to receive. So I guess we're here just so you could.
Mr. Spears, unfortunately, I think I kind of have to disagree with you. I've had dozens and dozens over the years of cases where a default judgment has been vacated, but as a condition of it, there was the payment of attorney's fees for filing the default. I think that is part of the rules, unless there was an issue with service that caused the default judgment to occur, but it doesn't sound like that's the case. And so I don't think Ms. Mann is wrong about that. That's something that's actually very commonly done in these types of cases. So was there a defect in service? It doesn't sound like there was.
No, sir, it was not. We did our due diligence and attempted to serve the defendant through 4 or 5 attempts. And we actually had someone answer the door the second time and confirm that the defendant did live there, but was not home at the moment. The second time, we actually provided our service processor with a picture in which he confirmed that was the individual that he spoke to the first time. We actually did a search as well to determine that the house that the 106 service prompted was actually a home owned by a family member. So after the due diligence, then we filed the motion for the 106 that was approved and posted on the same door. In addition to that, after we filed the 106 motion, it was approved and we had met service, we actually contacted the defendant's insurance company to let them know that the defendant was properly served. And at no point in time throughout the process, anyone answered. The insurance company responded back and said that their time had not been activated because the defendant never responded to them or reached out to them for representation. So that's how the motion for default judgment was filed after service was completed. And again, based off the defense counsel, we're not saying that we're not agreeing to the motion for new trial. We're just asking for the attorney fees for the process of filing the petition, service, all the way up to the motion for default judgment, and granting the default judgment. And we'll agree to a new trial, but we're asking for those attorney fees.
Okay.
Right, but those would be taxable only if they succeeded at trial. If they completely get poured out at trial, they're not entitled to any of those fees, and the defendant shouldn't be responsible for that.
Mr. Spears, I don't think that's the law. I have to agree with Ms. Mann. Now, I have done this different ways. I have had situations where it's not payable until the time of judgment, and I've had other cases where it's payable more quickly. But I don't think that it's a situation. It's going to be a taxable court. It can be a taxable court cost, but it would be recoverable whether she prevails or not. And so I disagree with you, Mr. Spears, on that, unfortunately. Ms. Mann, what are you requesting for attorney's fees? And it's just the attorney's fees for getting the default. It's not all your attorney's fees.
Well, we asked for attorney fees of $1,200, and it was including from the petition all the way through service and for the default as well. So the court determines they want to alter that amount and give attorney fees that's for default judgment. We're not against that. We just asked for the $1,200, and that accumulated the cost of drafting the motion for the default judgment, attending the hearing for the default judgment, and the entire process of the litigation thus far. Because had the defendant responded, we wouldn't have been here, and all the fees would have been taken care of if and when the case had either settled or we had reached a judgment at trial.
Okay. Response?
Well, I mean, requesting filing fees, that's taxable only if they prevail. So I guess if they itemize the expenses to have the service attempts made, that would, under what it sounds like your Honor's ruling is going to be, that would be, I guess, acceptable.
They can just recover the attorney's fees that were required to get the default judgment. They can't recover filing fees. They cannot recover the cost of attorney's fees for preparing the petition. It's only the attorney's fees that they incurred for obtaining the default judgment. Unless the law has changed very, very recently. I did one of these, I think, just last month. That's the only attorney's fees they can recover. So you're right about if they're trying to get filing fees, they would have to be the prevailing party at trial. But these attorney's fees are going to be taxed against your client, whether the Ms. Mann's client prevails or not. But we just need to figure out the amount of the attorney's fees that were necessary for the obtaining of the default judgment.
Yeah, and Ms. Mann, if Ms. Mann is willing to send me just an itemized receipt, I'm guessing pursuant to what the court is going to rule, I will submit that, and we will.
Ms. Mann, I mean, Mr. Spears, usually what we see on this is something between $750 and $1,200. Sometimes more on more complicated commercial cases, but on car wreck cases are usually kind of low. Could you just agree to $750, Ms. Mann, kind of on the lower end? And
yes, Judge, that's for, yeah. Yes, sir. I can agree to $750 in attorney fee.
Spears, can you agree to $750?
Your Honor, I wish I could tell you yes. I don't have the authority to spend the money arbitrarily. I have to present it to, additional parties, and it's.
I'm not asking you to pay the money. I'm just asking you that would be the amount that would be payable at the time of judgment. You can still, that is the reasonable and necessary amount. And then you can, at some point in the future, if you decide this has not been done correctly, you can challenge it, I guess. But it's just agreement that that's the reasonable and necessary amount.
Well, again, Your Honor, I appreciate the number, but I can't agree to it arbitrarily. I have to have documentation, or
let's just do a hearing on this. Then let's go ahead and do a hearing and prove this up. And I mean, 95% of the time, Mr. Spears, we do this, there's an agreement, and I think Ms. Mann has been very reasonable, but I'm not trying to give you a hard time. It's just, but we do have to get this resolved.
You know what, Your Honor, that's fine. I'll beg for forgiveness rather than ask for permission. So
you'll blame the judge is what you'll do. I've been in that situation before too. So just blame the judge there.
Yeah. I just wish we had a record.
So, all right. So let's go on the record real quick about this. Let's get this case. Which case is this? This is the motion for new trial. Tony, are you there?
Yes, Judge.
Let's go on the record on cause number DC 20-17429, Billy Ford versus Maria Romero. Counsel, make your appearances.
Sneak man, counsel for plaintiff Billy Ford.
Michael Spears for the defendant.
All right, we've had a discussion off the record. The court has agreed to grant a motion for new trial conditioned upon the payment of attorney's fees that were incurred by the plaintiff in the obtaining of the default judgment. The plaintiff originally requested $1,200, but through the able advocacy of Mr. Spears, she agreed to reduce that to $750 as reasonable and necessary attorney's fees for obtaining the judgment. Is that agreed to, Ms. Mann?
Yes, Judge, it is.
Mr. Spears?
Yes, Your Honor.
All right, guys, let's go off the record. And you'll need to prepare an order that says that, Ms. Mann. So make sure that you prepare the order. When you prepare the order, if you could say on it that this hearing was held on May 24th, 2021. Also, the order will need to say that this is conditioned. We're not even going to do the conditioning language, that this will be paid at the time of judgment. The attorney's fees will be paid at the time of judgment. And when do you want to set this case for trial?
Oh, I think we're both going to have to look at our calendars and get back to you on that one. I don't think that's something we can do right now.
Well, let's just set. I need to set it. So you want me to set it like in March next year, April, something like that? As
far back as you can, Judge, at this point.
Yeah.
You want to shoot for May?
Yeah, that's about a year from now. So,
Mr. Spears, how does that sound for you?
Yes, Your Honor. Whatever makes it easier for Ms. Mann, I'm agreeable.
Okay, let's do May 17th.
Okay.
And Ms. Mann and Mr. Spears, make sure you get that order in, because it doesn't become effective without an order. So we do need an order that conditions upon the payment of attorney's fees at the time of judgment.
Yes, Your Honor. I'll get that over to you ASAP.
All right, thank you so much. And make sure you share it with Mr. Spears.
Yes, sir, I will. Thank you so much, Judge.
Thanks, you guys.
Are we dismissed?
You are excused.
Thank you.
Is everyone here on the Grove Johnson versus Gallica case?
Your Honor, yeah, this is Chad Taylor for the plaintiffs, and my client is here. She's under Anna Love, but she's here in the meeting.
Anna Love. I don't see Anna Love.
Would you say hey, Avita?
Oh, there she is. I see her. Okay. And then the guardian litem is Heather Long. Who's the defense attorney here?
Andrew Eder on behalf of the defendant, Your Honor.
Okay. All righty. So is that everyone that is here? Ms. Long, have you submitted, has there already been, I'm sorry?
Yes, everyone is here. Sorry, Your Honor.
Have you already submitted a guardian litem report?
Your Honor, I have one written. I did not know if you wanted me to submit it through the e-filing system or not. I can present it orally and submit it after if you'd like.
That's no problem. I just need to know, I guess, what the settlement is and what the breakdown is. Is there a proposed judgment already that's been submitted?
Yes, we have a proposed judgment. I believe that it had been submitted, but I'll check with Mr. Eder. Andrew, did you submit that?
Nope, sorry.
Okay.
I'll get it submitted. We've all agreed to it, Your Honor. And this is what you'll see once we go on the record. This was a pretty simple one once we sorted a few things out. So
what's the overall settlement?
The overall settlement involves a three-party rec where the settlement includes a settlement for Miss Grove Johnson's injuries. It's a $19,000 settlement where the minors, minor ET and minor TJ. ET is a female older sister. TJ is male younger brother. We're also injured. The division is $7,000 to Miss Grove Johnson, then $6,000 to each minor. Miss Grove Johnson's injuries required a little bit more treatment and had a little bit higher medical bills.
And what is the amount that goes, and is money being deposited in the registry of the court?
Yes, money will be deposited into the registry of the court in the amount of $1,688.92 for minor EJ. And in the registry of the court in the amount of $1,684.54 for minor TJ, and that's after an Optum lien medical and reduced attorney's fees as well as reduced medical.
Was there a PIP claim?
No, there was not a PIP claim. This is all third-party insurance.
Was there PIP?
Not that I'm aware of. Let me check my notes, Ms. Johnson. Where'd you go? Now I've lost you. Oh, there you are. I don't remember you having first party UM/UIM coverage or PIP. Did you have personal injury protection coverage? We can see your mouth move, but I can't hear you.
I'm all muted.
I can't hear her.
I know you broke up for a second. I could hear you briefly. Try again. You did not have a personal injury protection coverage?
No, I did not.
Making sure.
Mr.
Yes,
Taylor, did you verify? Ms. Taylor?
I'm looking, I don't have anything in our file suggesting that you did.
Okay. All righty, let's go on the record on cause number DC 196567, Avita Grove Johnson versus Galicia. Council, make your appearances.
This is Chad Taylor, attorney for the plaintiffs.
Andrew Etter on behalf of the defendants.
Heather Long, the court-appointed guardian ad litem on behalf of minors EJ and minor TJ.
See?
And I'm
Yeah.
Avita Grove Johnson.
Sorry, Avita, could you please state your name for the record?
Do you want me to swear her in?
Yes, let's swear in.
Yes, Your Honor, sorry.
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Please state your full name for the record and spell it for the court reporter.
First name is Evita, E-V-I-T-A. Last name is Grove Johnson, Grove. Is hyphenated, Johnsson.
Thank you, Ms. Leff.
Ms. Johnson, did you bring suit against defendants individually and as parent and next friend of EJ and TJ, that's how we're going to refer to your children, for personal injuries occurring on or about July 7, 2017?
Yes, sir. Yes, sir.
Would you say for the record your relationship to EJ and TJ?
They are my children. I'm their mother.
What are EJ and TJ's birthdays?
EJ birthday is May 5th, 2004, and TJ is June 4th, 2007.
Would you please briefly describe the incident that resulted in this case?
It was a motor accident.
And could you please briefly describe what injuries TJ and EJ suffered due to the accident?
They had some back injuries.
Are EJ and TJ continuing to have any medical problems as a result of the incident?
No, sir. Thank God.
And we are here today to settle your case against the defendants. And is it your understanding of the settlement terms that the defendant and his insurer will pay $6,000 for TJ, $6,000 for EJ, and $7,000 for you individually?
Yes, sir.
And you understand that the $19,000 total is all the money which the defendants and their insurer will pay you and your children as a result of the incident?
Yes, sir.
Do you believe it's in the best interest of EJ and TJ to settle this case in accordance with the terms we've outlined?
Yes, sir.
Do you understand that by not settling this case, you would be entitled to a jury trial?
Yes, sir.
Do you understand that by settling this case, you're giving up that right to a jury trial?
Yes, sir.
And do you understand that by accepting this settlement today, any existing injury to you or your children and any injury which may arise or develop in the future would not be recoverable from either the defendants or their insurer?
Yes.
Based on all that we've set forth in the record today, you still want the judge to approve this settlement?
Yes, sir.
I'll pass the witness.
All right, Mr. Etter,
No questions, Your Honor.
Ms. Long.
Yes. Ms. Grove Johnson, excuse me. I just want to real quick go over just a few things. I'm going to try not to repeat your council's questions too much. The wreck that occurred on July 7th, 2017, now it occurred while you were in the process of turning into a parking lot and you were the driver of the vehicle.
That's right.
And your children, E.T., who is your oldest daughter, and T.J. were passengers who were wearing their seatbelts in the back.
Yes.
As I recall from our conversations, you attempted to contact the police, the parties did, and the police did not come out or make a police report on this.
Yes.
And in the course of the days that followed the wreck, can you tell us a little bit about what injuries E.T. had?
Well, most of their injuries were in the back from shoulder towards their lower back and pain.
And following the wreck on the next day, E.T. went to get examined at Baylor Irving Medical Center, correct?
That's correct.
And after that, the records that I've seen and what we've discussed is she went through about a month of chiropractic treatment.
That's right.
And that treatment helped her get through the injuries.
Yes, ma'am.
And TJ, he also went to Baylor Irving Medical Center after the day after the collision, right?
That's right.
And what type of injuries did he have?
Just as his sister, they both had complained about back pain, shoulders.
And he did also about a month of chiropractic treatment and saw improvement.
Yes, ma'am.
All right. And you were also injured in the wreck and you also incurred medical bills, right?
Yes.
Okay. When you retained the law for I believe it's Raleigh law now. I keep wanting to say Raleigh Breedland because that's what it used to be. When you retained Raleigh law, you retained those lawyers to represent you and your children, right?
Yes, ma'am.
And you and I have talked several times about how the settlement broke down, what your understanding of things were and how the kids are doing now, right?
Yes, ma'am.
The proposed distribution of this settlement, as your attorney mentioned, is the $19,000 being broken down into $7,000 being attributed to you, $6,000 being attributed to EJ, and $6,000 being attributed to TJ. I want to go over now that with you, just as it relates to your two children, about how that money for each of them breaks down. First off, is it your understanding that the balance of what of the settlement dollars that each of your children get are going to be placed in the registry of the court?
Yes, ma'am.
And we've talked about how that's a special account that the court is able to hold money for individuals like minors, and that your children will be able to obtain that money on their 18th birthday, right?
Yes, ma'am.
So when we look at the funds for ET, who is, she's what now, just turned 17 this month?
Yes, she did.
Of the $6,000, you understand that the attorney's fees of 1/3 are $2,000 that are being paid as attorney's fees to the law firm that represented you, right?
Yes.
And then Out of the $4,000, there are medical bills and a lien from Medicaid that need to be paid back, and that the law firm that represented you did a good job of, or I won't qualify their work, but I will tell you they did, at least from my perspective, did a good job of getting reductions in that medical, in those medical bills. Is it your recollection that your ET had a little over $6,000 in medical bills before reductions?
Yes, ma'am.
And of those medical bills, those have been reduced to an amount of $1,152 for medical that was not paid by Medicaid. Is that your understanding?
It is.
And that's going to be paid out of this settlement if the court approves it, right?
Yes, ma'am.
And in addition to that, Optum, which represents Medicaid, paid $917.27, and that has been reduced to $611.51. Is that your understanding?
It is.
And that's going to be paid also out of these funds, correct?
Yes, ma'am.
And finally, your attorneys had some court costs and expenses in relation to filing the lawsuit, that a third of those court costs is being spread amongst each you and your children's recoveries, as well as the expenses that are attributable just to the children. And the total amount of that comes out to about it comes out to $549.42. And you understand that that also is taken out from ET's recovery, correct?
Correct.
And the total, when we do the math of money left for ET's from that settlement for ET, is $1,688.92 that would be deposited into the registry of the court for her until she turns the age of 18. Is it your opinion and recommendation that that is in the best interest of your child, ET?
It is.
And as we, now we're gonna do the same thing for TJ. TJ was about 13 at the time, or excuse me, is now almost 14. He'll be 14 pretty soon, right?
Yes.
And again, out of this $6,000 settlement for TJ, and if, I think I've been saying ET instead of EJ because I'm looking at and I apologize to y'all. Again, $2,000 of 1/3 for attorney's fees are being taken out. And of the $4,000 that is left from that settlement, an Optum lien of $611.04 will be paid back, which is a reduced amount from $921.06. Is that your understanding?
It is.
And in addition to the repayment of the reduced Medicaid Optum lien, the total medical bills for TJ were approximately $6,170. Is that your recollection?
Yes.
And those have been reduced to $152 as well. Is that your understanding?
Yes, ma'am.
And you understand that those costs, as well as the court cost and expenses in this case, are all going to be paid before, out of the $4,000 that is left after attorney's fees for TJ's settlement.
Yes.
And the remaining dollars that are attributed and will be paid if the court recommends or accepts the settlement into the registry of the court for TJ are $1,684.54. And is it your recommendation that the court approve this as in the best interest of TJ?
Yes.
And you've had a chance to talk with your attorneys and talk with me, and you know that if this settles, the case is over no matter what happens later, right?
Right.
And that the money that's going into the court registry for each of your children, it's each of their money. It's not my money. It's not your money. It's not the court's money. It's not your attorney's money. It's for them, right?
Right.
And with that, I will pass the witness.
All right, Miss Love, do you have any, I'm sorry, I have the name. Miss Grove Johnson, do you have any questions for me?
No, Your Honor.
And do you feel like this settlement is in your children's best interest?
Yes, Your Honor.
All right, Miss Long, do you have a recommendation for the court?
Yes, Your Honor. I had the ability to talk with Ms. Grove Johnson several times and go through the records and the pleadings. And it is my recommendation that the court accept and approve this settlement.
Okay, the court will approve the settlement. Please get me a judgment as soon as possible. And in the judgment, make sure that it says that, has that already been drafted and done?
Yes, we have an agreed judgment and I can file it with the court. What did you want to make sure it included, Your Honor?
Just that it has signatures from all parties and that you email it to Rhonda as well as e-filing it. And
absolutely.
Ms. Long, I know you haven't done many of these for me. Just with the pandemic and everything being virtual, it's really helpful to have those in advance so that I can kind of look at them. So just FYI for future.
Absolutely, Your Honor.
Usually you just bring them to the courthouse and hand them to me, but
I know.
Your Honor, I will say that we got it this morning exchanged. My e-filer is out with electricity issue at her house.
Okay.
Otherwise, it would have been filed just prior to the hearing. So I will apologize for that, Your Honor.
That's okay.
Yes, Your Honor. And I usually contact court coordinators and say, hey, would you like us to send a, cheat sheet beforehand? And I'm sorry, I just didn't get a chance to do it. I was in mediation on the end of the week. So
no worries. No worries. All right. Well, thank you so much for your service, Ms. Long. Go ahead and just get me that judgment as soon as you can.
All right.
And you guys be safe. Okay.
Oh, and Your Honor, we have submitted.
Oh, and that's right. We need an attorney for the guardian ad litem
yes,
fees.
and I have submitted the order for the guardian ad litem fees. I spent just under 10 hours. My standard hourly rate is $300 an hour, but I went ahead and reduced for 20% for ad litem fees. The total came out to $232, and it's agreed to.
Is that agreed to, Ms. Etter, Mr. Etter?
Yes, Your Honor. There's no objection on behalf of the defendant.
All right, just make sure that you submit an order on that as well as it's usually best to have it in the judgment as well. But if it's not
yes,
in there, just as long as it's somewhere.
Yes,
all right, well, great, guys. Thank you so much.
No problem. Thank you.
You guys be safe.
Thanks. May we be excused?
You are.
Thanks.
I believe our next case is Torres v. Hill. I think I saw the attorneys there earlier, Mr. Eaton and Mr. Grasso.
Mr. Grasso is here, Your Honor.
And I saw Mr. Eaton as well.
Chad Eaton here for the plaintiff, Your Honor.
Okay. And this is a status conference, I think, and just I wasn't sure exactly. It's about a trial conflict or something. And so what's going on?
Your Honor, I'm the one that I guess the request of this. I had the case of Torres versus Hill originally on your docket. It's probably my mistake for June the 23rd. But I see that, at least that's what my notes said, but apparently it was scheduled on July the 19th. in your court, but I also have the Randall versus Clements case scheduled that same day in your court. So I've got an irreconcilable conflict. And so,
So should we reset this to June 23rd? Is that kind of what you're asking for?
well,
Or is that when it was supposed to be set? I mean, it could be
no,
our
that's okay.
mistake.
So Mr. Eaton and I are together on Torres versus Hill, and I originally thought that was scheduled for June the 23rd, but maybe there's another case already scheduled for June 23rd now in this interim. So I don't quite know what to do because I can't try two cases at the same time on July the 19th.
Mr. Eaton,
I don't have any objection to that, Judge.
you want to set it on June 23rd?
Let me look real quick, Judge.
So I have 2 dates that I can try cases this next 2 months, and that's on June 23rd and July 19th. And so if we made a mistake, I apologize, Mr. Grasso. That's very possible. And so if it's supposed to be on June 23rd, we're happy to move it to that date and send you a new trial setting.
And either one is fine with me, Your Honor. I didn't know if you had someone else scheduled on June the 23rd in the interim.
I have a lot of cases set on June the 23rd.
Oh, I see.
We haven't had jury trials in 15 months. And so we want to make sure that we're going to use that date because it's the only date I get to try cases in June. So
Yes,
we're loading up. How long is this case going to take to try?
It'll probably be a one-day case.
I agree.
Mr. Eaton, do you agree with that?
Yeah, that'd be perfect then. They want us to do a one-day trial if possible. So that would be a perfect case to try if we can. So Mr. Eaton, you're okay with June 23rd?
I have another case in the 68, Alice Jones, set for June 23rd. So however it shakes out with whichever one's older, it looks like I'm probably going in your court that day either way.
And I just want to remind you, I don't know if I told, or maybe not remind you, but I've been telling attorneys, and I don't recall if I told you guys, but we usually go in date order. This time we're going to give preference to anyone who'll agree to a 6-person jury because I think it's safer. But if there's not an agreement, then we'll just go with the oldest 12-person jury case. So I don't remember. Did you guys already agree to a 6-person jury on this or no?
I don't believe we have, Your Honor. Chad, what do you recall?
I don't object to 6-person with catching up from 2020 and everything else. My client authorizes 6-person juries in these cases.
Mr. Grasso?
I don't have authority for a 6-person jury. I'd have to check with this is an insurance case. I've checked with the claims department, but right now I don't have authority for a 6-person jury.
Okay. Yeah, just let us know. I mean, it's, and you know that there's going to be a pretrial on this case on June 22nd. And so just be ready, have all your motion limites done, make sure you've conferred on them, your exhibits lists have to be done. We're going to try to deal with all the pretrial issues on June 22nd, because on June 23rd, we're not going to have any time that we're going to be going directly to the central jury room to pick the jury. So any pretrial issues have to be dealt with on June 22nd. And that will be remote. June 22nd will be remote. June 23rd will be in person. Did you guys have any questions about that?
I think it's okay, Judge.
Mr. Grasso, did you have any questions? You're muted, sir.
Apologize. There we are. I apologize.
You muted yourself again, sir.
Are we there?
Yeah, there we go.
Oh, good. Sorry. I keep my hand off the button there.
Yeah, it's tricky.
Yes, sir. So I have not received a trial setting for my July the 19th case yet. So I guess we'll be getting one here on this June 23rd case.
You haven't received a notice from us on that?
No, sir, not on the Randall versus Clements case on July the 19th. It's a 19-1296.
I'll talk to my coordinator about that. I'm not sure why you haven't gotten it. That's what we discussed, and that's what I told you it would be said. It was July 19th.
Yes, sir.
Okay. Let me, all right, guys, we'll take care of that and I'll, you guys be safe, okay?
Thank you,
Thanks,
Judge.
Judge. See you soon.
And you too.
May we be
let me-
excused?
You may be. Thank you so much. Give me 1 second for the next case. All right, are both sides here on Lenahan Law Firm versus Huffsey? I saw Mr. Marie.
Nice to hear, Judge.
Yeah, here, Judge.
Okay. Mr. Marie, I thought I saw on Facebook that you just ran a marathon.
A little further, like 2 marathons.
Wow.
52 miles. Yeah.
That's very impressive.
Appreciate it. A lot of walking. I can assure you of that. I can't run
Did-
52 miles.
Did you do it in 2 days or 1 day?
12 hours.
Wow,
I was 3 minutes away from being in 3rd place. I finished in 4th place.
that's great. That is great. Well,
But
very
there was only
impressive.
34 runners, so I'm not like
That's still great that you finished it is impressive to me. So
I appreciate it.
all right. So we have here on a motion for continuance. What kind of tell me what's going on?
And Judge, this is my motion, and I'm hoping. Do we have a court reporter on this?
Sure. Tony, are you there?
Yes, Judge.
Let's go on the record on cause number DC 2018255, Lenahan Law Firm versus Huffsey. Counsel, make your appearances.
Eric Marie for the defendant.
I'm Calvert for the plaintiff.
All right. Go ahead.
Judge, this was my motion. I realize that this is sort of a different type of case and that we're just here for, Steve's attorney's fees. But I do think that there are some fact issues that are still out there that need to be resolved before a summary judgment can be decided. And I realize you're sort of just trying to get a framework of how the case will proceed discovery-wise. And I'm certainly, I can agree with Mr. Coward on some of those issues. I think we can submit something, but I'm just concerned that having a summary judgment hearing and then an order on summary judgment without giving me a chance or my clients a chance for discovery is premature at this point. So that's why I filed the motion for continuance.
Mr. Coward.
Judge, this is the same issue that we've had 2 or 3 hearings on now, where they don't like the idea of doing a summary judgment motion on a legal issue, which is all we're doing in this motion. It's a question of what the measure of damages or the methodology for determining damages on quantum merit is. In the last hearing we had on the motion to compel, Mr. Marie agreed that he was just going off the quantum merit claim, no contract claim, no promissory estoppel claim, strictly on quantum merit. Your order from the April 3 hearing is clear that the sequence of events is let you figure out, make a ruling on what the scope of discovery is, so we can then do discovery. That's the point of this motion. If there are really facts.
Mr. Murray, is there a way that you guys could just, I mean, since now we've narrowed it down to just quantum merit, is there a way we can just reach an agreement as to the methodology for that? I mean, is that, or what the proper measure is, I guess, not the amount, but the proper measure?
And there is, Your Honor. I think our briefing is pretty much the same. I mean, I think the Arthur Anderson factors are going to be relevant. I think the only issue really out there is whether the jury or you get to consider the contingent fee of the contract and what the result was. I think those are the only two issues. The problem is some of that hinges on the contract or the agreement between Nash and Steve and whether it's statute of frauds and things of that nature. That's why I'm saying there's fact issues out there. And if you look at the plaintiff's motion, they start out with a lot of undisputed facts that several of those are very much in dispute at this point, Judge.
Your Honor, if there are disputed facts, then the proper response is to file a proper procedure would be file a response to the motion. That's what happens with motions for summary judgment. I don't think there are disputed facts. There's certainly no disputed facts at this point. If Mr. Marie has disputed facts, then he should present them. That's part of what we're trying to accomplish here, is identifying what has to be involved in discovery. And the way you do that.
At this point, I'm going to deny the continuance, but I do want to make it clear that that this is a very limited scope summary judgment. It's just what is the proper measure of damages. I kind of thought that there would be at least an argument about what the proper lodestar would be on this, but is that not something you're going to be pursuing, Mr. Murray?
Absolutely, we are. Well, the lodestar, the case law says that that's just one factor of Arthur Anderson, whether there's a lodestar adjustment, and that's the contingency fee and the result, that recent Hill case. But to answer Mr. Cowart, we don't have any facts in this case because we haven't done any discovery. We haven't taken one deposition. We don't have any stipulations on the record. So there's no facts before the court that the court can make a summary judgment decision based on.
And Judge, to dispute that, we attached an affidavit to our summary judgment motion. So the facts for the summary judgment motion are presented. It's not a no evidence summary judgment motion. And to clean up the record on that issue, our facts are supported by an affidavit.
And my client's dead.
I understand, Mr. Marie, exactly where you're coming from. And I think in most cases, if we were talking about a summary judgment on the amount of the attorney's fees or the multiplier for the lodestar, I would agree with you. And maybe now that we're just dealing with quantum merit, maybe this is not even necessarily needed, because I think that clarifies a lot of issues, that it's just quantum merit. But that's why I was suggesting just reach a stipulation as to this is what the proper measure is, then let's go do discovery on that measure. If we can't even get that basic information stipulated to, then I do think a summary judgment would be helpful so that we can determine the proper scope. If it turns out that they're trying to overreach in the motion, and I haven't read the motion, so it's not set for today, and they're trying to get something else, or they're trying to do a no evidence, or they're trying to, go beyond this scope, and you need discovery to deal with factual issues that are in dispute, I absolutely will give you continuance at that point. Does that make sense?
Yeah, it makes sense, Judge, and that's why I'm having this hearing, I think.
Yeah, I understand.
Okay.
I just want to make sure that we're on the same page. So, all right, guys, good to see you, and we'll go from there. Okay, thank you so much.
Hey, Tom, I'll give you a call if that's okay. We'll see if we can discuss some of these issues. All right, thanks, Judge.
Good to see you guys. Angel Sword versus Watson. I think I saw
Morning, Judge.
Mr. Vassar here and Mr. Henley.
Yes, Your Honor.
Good morning, Your Honor.
And then is Mr. Hill on this case as well?
I am, Your Honor.
Okay, I just want to make sure everyone up here. Mr. Ellis, are you on this case or the next one?
I am, Your Honor. On this one, I'm the new attorney, so to speak.
Okay. All right. let's go on the record, Tony, on cause number DC 207334, Angel Sword versus Watson. Council, make your appearances.
Good morning, Your Honor. Jeff Henley for defendant Oksana Watson.
David
Matthew Hill
Vassar for the plaintiff, Angel Sword LLC.
Matthew Hill for third-party defendant Daniel Watson.
Let's proceed.
Your Honor, this is the motion to substitute Michael Ellis in for myself. As the court may recall, at the last hearing, when the family law claims were abated and severed, I made the court aware that my client would be seeking new counsel. He secured Mr. Ellis to represent him. For one reason or another, Mr. Henley is opposed to that substitution. I guess he's claiming that we're causing some sort of delay. I'm not sure what that delay would be, since Mr. Ellis would have been in the case a week to 10 days ago if he weren't opposing my substitution. But I would ask the court to grant the motion to substitute to allow the case to proceed and allow me to focus on the divorce case in Hays County.
Response?
Judge, Mr. Hill mischaracterized my position as he did in his motion. I stated from the get-go that we would be unopposed if we received a representation that they were not using this as a form of delay. And I made it very clear to him 28 minutes when he first emailed me, and he didn't respond. And as a general proposition, I absolutely agree with the notion that, people get to choose their own lawyer, and they well should. But they absolutely shouldn't be able to, jump in and jump out of cases irrespective of the posture of a case. And all I was seeking from Mr. Hill from the outset was a representation about that, because if he could say so definitively, I was not going to oppose the motion.
And Your Honor, if I can respond.
Sure.
Mr. Henley keeps claiming that I didn't respond. In the exhibits that I attached to my reply, his response, I included the email where I responded to him moments after he emailed me, and copied Mr. Ellis on that email and forwarded him that email, and said that I would have to allow Mr. Ellis to address any concerns about delays. And then Mr. Ellis emailed Mr. Henley and his staff and responded concerning the delay. I don't understand why Mr. Henley continues to misrepresent to this court that he wasn't responded to, but all these emails took place in less than an hour. He was responded to. He was told by Mr. Ellis in Exhibit B to my response that he is not, excuse me, I appreciate the effort to horse trade, but I am new to the case and not in a position to swap anything for what is commonly a rubber stamp motion. Your client elected to add a new party at the 11th hour, and that can impact deadlines, although I did not anticipate such at this time. So Mr. Henley got his response about whether there was going to be a delay. In the motion itself, it stated when I drafted it that
let me just say this, that I've been doing this a long time, and when I was a brand new judge, I typically would probably give continuances, a couple, 3 times if there was new counsel. I've become a lot stricter on that because I have seen it used strategically so often. And so Mr. Henley, I've dealt with this issue before, and I understand your concern. I am not going to grant a continuance solely because there's new counsel. If I will grant continuances if there's a change in position of the parties, if there's new pleadings that cause there to be new counsel, but at this point, just because there's new counsel, I'm not going to be granting any type of continuances solely for that basis, if that helps resolve.
That helps tremendously, Judge.
All right.
Your Honor, we wouldn't ask for continuance on that basis, and it's not appropriate to do so. So that's not the point of this motion. Mr. Henley's request went far beyond anything relating to delays relating to new counsel. He wanted a promise of no request for a continuance, and that's really where the rub is.
Okay. I didn't see an order attached. Did you guys submit an order for the substitution of counsel?
I believe an order was submitted, Your Honor. I'll check with my staff.
But let me look. Maybe I missed it. I didn't see it. There's been so many things filed in here. Order of substitution of counsel. Do you know when that would have been filed?
I'm messaging my staff right now, Your Honor. If you would bear with me, please.
And they may be, there's the motion. Let me see if this is the order here. Okay, yeah, I found it. It was just not it wasn't filed simultaneously with the motion, which is fine. Let me just go ahead and print this out. Great, it's not printing. All right. I'll go ahead and print that out and get it signed right now. Anything else, guys?
No, Judge, maybe we be excused.
You may. You guys have a good day, okay?
Hey, you do the same, Judge.
Thank you, Honor.
Thanks, Judge.
Thank you. Okay. Mr. Poteet, what are you here for, sir?
Well, I've got an unopposed motion for attorney's fees that on the Casanova case, your court coordinator told me to call in.
Okay. I don't have that on the docket, so give me 1 second.
Would you like the cause number, Judge?
Give me 1 second. I have to print out the order from the last hearing.
Okay.
So.
Sure.
Yeah. Give me 1 second, though. I'm about to print it. Okay. Okay, I just printed it.
Okay.
All right. So you said you had a cause number. Let me look it up real quick.
Sure. It's DC 20.
No, give me 1 second. I'm not there yet.
Okay.
DC what?
20-11199.
Okay. And what this is on the New Hampshire Insurance Company case?
Yes, sir. It's just an unopposed motion for attorney's fees. We have to submit them because it's a workers' comp case. We have to submit those quarterly. And so we've submitted one.
I think I already signed this. Was this submitted on the 14th?
Yes.
Yeah. So according to this, it's forwarded signed orders on the 21st to the clerks.
Okay.
But they haven't scanned it yet. So.
Okay. That's all I needed. I won't keep you, Judge.
Okay. Well, sorry about that you had
That's
to
okay.
sign on.
I appreciate you taking the time.
No problem.
Have a good day.
Okay. So